and an appeal in the matter of R on the application of Rights Community Action Ltd versus the Secretary of State for Levelling Up Housing and Communities.
Mr. Gibbon.
My Lords, I appear for the appellant with my own friend Mr. Shattuck. Mr. Westaway appears for the respondent Secretary of State. Mr. Troman's KC and Ms. Keating appear for the Office of Environmental Protection.
Thank you.
The court also has written submissions on behalf of Green Alliance and the Essex Planning Association.
And more recent submissions from the Speaker's Council.
Yes, my Lord.
Yeah.
The court should have a core bundle, a supplementary bundle, a core authorities bundle, a bundle that is called a privilege authorities bundle, related to those issues raised by the Speaker. And there was a short additional bundle of 3 documents filed by the Office of Environmental Protection.
Yes, thank you.
I don't have either the Speaker's letter, although I read it, and I don't have a bundle of authorities dealing with questions of parliamentary privilege, just so that you know. But maybe that we won't get to those in this hearing anyway.
Well, I'm grateful for the indication of that, my Lord, because perhaps we should just address how to deal with the Speaker's letter at the outset. I sent an email last night, I don't know if it made its way to my Lords through the clerks.
Yes, we've seen that. Yeah.
The position which, between the appellant and the respondent, we propose to adopt the approach that was taken in the West Berkshire case at first instance, where a very similar challenge was brought to a written ministerial statement, which then avoids the need to confront questions of parliamentary privilege or Article 9 directly, and which seems to accord with the position taken also by the Speaker, which is that if the remedies are, in the event of a successful appeal, a declaration as to the written ministerial statement or a declaration as to the decision to make the written ministerial statement, as opposed to any remedy quashing or directly confronting the statement put before Parliament, then that stops short of engaging with the potential questioning or impeaching of parliamentary proceedings in breach of Article 9 of the Bill of Rights.
Well, I mean, there is an argument that even commenting on the written ministerial statement engages Article 9 in any event, but in circumstances where the statute has provided that that's the way in which this particular guidance is to be given, there seems no other way around it.
Well, my Lord, if my Lords are happy to proceed on that.
Could I just ask about the first Rights Community Action case in front of Mrs. Justice Lieven?
Yes.
In fact, the relief granted there didn't involve the quashing of the WMS. It looks as if the Secretary of State withdrew the WMS.
That's right, yes.
2015, before judgment was given. So that perhaps explains why this issue wasn't addressed in that case.
Yes, the first case was a challenge to the West Oxfordshire District Council's plan.
No, I'm talking about the Rights Community Action case, which was a challenge to the 2015 WMS, wasn't it? The first decision of
yes,
Mrs.
but
Justice
the relief.
Lieven.
Yes, but the relief didn't directly bear on the written ministerial statement.
That's because the government withdrew the WMS before judgment came out. I'm just reading anyway, I don't want to waste time on it, but it seems to be paragraph 96, a postscript.
Yeah. But the remedy specifically sought was a challenge to the inspector's recommendation to adopt the West Oxfordshire District Council's plan. So,
okay, I'm with you. Sorry, I beg your pardon.
So there wasn't a question of remedy.
There wasn't a direct challenge to the WMS.
Yes.
Okay, thank you for that.
At some stage, I would appreciate a copy of the Speaker's letter and the bundle of authorities, because there are quite a number of cases dealing with written ministerial statements in different contexts.
Yes.
But don't worry about it now. But it would be nice at some stage to
get
catch up with everybody else and have everything else.
I can only apologise, and obviously the Speaker's letter came in yesterday, so I'm sorry that it hasn't made its way.
Well, these things always happen, but thank you very much for what we've got.
So, proceeding on that premise for now, of course, I'm content to revisit it tomorrow. Should the need arise, if the court is content, I'll press on with the substance of the appeal, and any further questions on parliamentary privilege, I'm sure, can be addressed
And just before you start, I imagine this is listed for 2 days, and
Yes.
have you worked out a sort of schedule of timings between each?
Yes, I propose to finish at some point shortly after lunch, but
Yeah.
probably not by lunch. My learned friend, Mr. Chomans, anticipates around half an hour.
Well, he's been given half an hour and
Yeah.
can take up to half an hour.
And then my learned friend for the Secretary of State would follow after that.
I was anticipating, because we were in touch about it
Yes.
by email just into council, and given 2 days, I suggested as long as I was on 11:30 tomorrow, assuming it might dribble over, so I was expecting to be on my feet tomorrow morning, in fact, rather than this afternoon. That was the timetable we discussed. If Mr. Goodman can make good pace, excellent.
Good.
But I think we have plenty of time in any event.
We have time, and there's no pressure on time. It's just so that we've got some idea. Okay. Well, thank you very much.
So, my lords, this is a challenge seeking, in the context of our discussion, a remedy in respect of the Written Ministerial Statement of 2023, which concerns energy efficiency standards in local development plans. There were 3 grounds in the court below, but in essence 2 points of challenge which are reflected in the 2 grounds before this court. The first being the challenge to the Secretary of State's compliance with the duty under Section 19 of the Environment Act 2021, and secondly to challenge the consistency of the WMS with the Planning and Energy Act 2008 Section 1. These are distinct issues with limited authority on each of them. The ground 1 is the judge erred in her interpretation of Section 19, and in the skeleton argument we summarise 3 key subcomponents of the ground. That she erred in holding that the duty can be discharged in a rearguard way, either in general or in this particular case, and in particular we say this was a rearguard action taken in the context of the adversarial litigation, and we'll look at the redacted ministerial submissions that and the particular steer to demonstrate compliance with the duty, and we say a fair-minded member of the public would consider the decision was improperly tainted by the JR concerns, or would be concerned that they were. And so in the context of the duty, it can't be regarded as an open-minded decision in all the circumstances. But even if that's wrong, we say the Secretary of State, secondly, failed to discharge the duty because the judge erroneously held the Section 19 duty could be discharged by an assessment that was directed towards the benefits of the future home standard, an inchoate policy, rather than by regard to the impacts of the WMS itself. And thirdly, that although the judge accepted the principle of the Section 19 duty, required regard to be had to the environmental principles policy statement with substance, rigour and an open mind, as the statement itself states. She erred in finding that the duty was diffuse or loose, and that the rigour required was discharged in this case in circumstances where in fact there was no regard to each of the environmental principles and no sufficient inquiries as to the impact of the policies on those principles or those affected by them, by the policy. And then ground 2 is the judge erred in the interpretation of Section 1 of the PEA and Energy Act 2008. Properly understood, local authorities enjoy power to set energy efficiency standards above the building regulations. It does not have to be set out in national policy. The error of interpretation tainted her consideration as to whether the WMS cut across the statutory powers of local authorities, including Section 1. So, my lords, before I set out the facts, I want to begin just with Section 19 itself, because bearing in mind the statutory provision will inform an understanding of the process by which a policy was developed. So that's in tab 6 of the authorities bundle. And we can start with Section 17.
So 6A on the electronic bundle.
Page 86 of the bundle. Tab 6. And section 17 provides the Secretary of State must prepare a policy statement on environmental principles in accordance with this section and section 18. Subsection 2 provides a policy statement on environmental principles is a statement explaining how the environmental principles should be interpreted and proportionately applied by Ministers of the Crown when making policies. 3, it may also explain how Ministers of the Crown, when interpreting and applying the environmental principles, should take into account other considerations. 4, the Secretary of State must be satisfied the statement will, when it comes into effect, contribute to the improvement of environmental protection and B, sustainable development. And then the 5 environmental principles are set out in subparagraph 5, which the court will have picked up from pre-reading and are set out there. Again, integration, preventative action, precautionary principle, the rectification at source and the polluter pays principle. Over the page at page 87 then is section 18. The Secretary of State must prepare a draft policy statement on environmental principles. 2 must consult and 3 must lay it before Parliament. And then section 19, a Minister of the Crown must, when making policy, have due regard to the policy statement on environmental principles currently in effect. Nothing requires, subsection 2, nothing requires a Minister to do anything or to refrain from doing anything if doing it or refraining from doing it would have no significant environmental benefit or would it be in any other way disproportionate to the environmental benefit. And then to understand what subparagraph 1 of section 19 means, we have to go to section 47, which is the interpretation section. It begins on 94 of the bundle, and the relevant definition is on 95. About 6 lines down on page 95 of the bundle, making policy includes developing, adopting, or revising policy. And so if we insert that definition back into subparagraph 1 of section 19, we see a Minister of the Crown must, when making, which includes developing, adopting, or revising policy, have due regard to the policy statement on environmental principles currently in effect. And so I want to begin by emphasising that focus on those 3 distinct phases. Developing policy, that's a process prior to the adoption of the policy. The duty is therefore one that is designed to permeate the development process. And in that respect, this duty is distinct from the duty we are familiar with, the section 149 public sector equality duty, which typically, although it doesn't have to, but typically applies at the point of adoption of a decision, the making.
Well, it actually says in the exercise of functions.
It does, my lord.
Which includes policy, but includes lots of other things as well. It depends what the function is.
Yes, my lord. And so can be applied to a single decision related to a single individual, or can apply to a broad spectrum of policy. But we can see in some of the authorities, I'll go to them in a second, that typically the way that's analysed, the exercise of the function, is the moment upon which the policy or the decision is made or adopted. It doesn't apply critically. It can do, but it doesn't dependently apply to the process of developing that decision. And so in that key respect, it's distinct from the definition of making in section 47 and section 19(1) of the Environment Act. And so again, if we can pick up the EPPS, the Environmental Principles Policy Statement itself, which is in the core bundle, and in the supplementary bundle. It's tab 1. It begins at page 4. And then the first substantial passage is page 6. And what I'm just going to highlight is the number of times that the references are made to the development of policy. and the application of the duty to the development of policy.
Can I just be clear? I had not understood your claim form in the judicial review to be challenging the process, making policy in terms of process, developing the policy. I'd understood it to be that when she adopted the policy, the relevant minister did not have regard. Indeed, she seems not to have known about Section 19. So I thought we were focusing on that bit of making policy, not the bit up to the decision.
That's correct, and that is conceded, my lord, as an unlawful act at various points in the skeleton argument of the respondent.
Yeah. So of the three stages, we're not dealing with the developing, we're dealing with the making, where it's conceded that there was a failure to have regard.
Well, the relevance of the developing is to the defendant's defence that no remedy is necessary in consequence of the conceded unlawfulness. So that's why I'm flagging that, because the defendant says, we accept it was unlawful not to have regard to the duty in adopting the policy, but in March, 3 months later, we conducted an analysis and that cures the defect sufficiently that no remedy is required. The importance of understanding the developing duty is to analyse that defence, that you can cure a duty which is required to apply both in developing, adopting and in revising by an analysis after the event. And so the submission will be that after the event analysis, in principle, I don't rule out the possibility of retrospective, in some circumstances, retrospective analysis being adequate to discharge the duty.
But can we be clear what we mean? There was a point in time in the history of the universe when the duty was breached, and that can never be changed.
And
what we're dealing with now is a different situation where at a different point in time, it is said that an assessment was carried out, the world had moved on. Now, if we'd stopped at the date when the policy was adopted and there was no due regard to Section 19, a question of an appropriate remedy would have risen, declarations, quashing and so on. But the world has moved on now, and when we come to the date when matters are looked at again, just as it would have been, for example, if it had been a quash and had been sent back, the question is whether or not from that time forward there needs to be a remedy in relation to the content of the policy statement. Still the question of what about that period of days or months when there was an adopted policy where there'd been no due regard, and as a matter of discretion you may or you may not want to grant a remedy. But can it really be said that if I breach the duty on Monday and adopt a policy, the following Monday I can retroactively undo the breach of duty, not for the past, but you can put in place a proper policy for the future, surely?
In principle, I accept that it's possible to do that, but the analysis has to focus on what is the nature of the breach of duty, and therefore what is the remedy that's being offered.
Can I try and help? As I understand the argument presented by the OEP as well as by yourself, because this duty expressly applies to the formation of policy stage, I think the suggestion is that if you have a case where the duty wasn't taken into account even when the policy was being formulated, as well as at the decision-making stage, it is more difficult thereafter to validate what has happened. But of course that would apply in a case where that might apply in a case where that is so. It does also give rise to this question, that if you have a case where the duty was taken into account during the plan preparation phase, but was simply omitted at the formal decision-making stage, it might be easier thereafter to validate after the event. So the argument is a bit double-edged.
Yes, it is.
Yeah,
I accept that.
Okay.
Yes. Both ways, my lord. Yes.
And I think we need to be careful about the word validate. Yes. We are not deciding whether or not that which occurred in November whichever year can be undone. The universe moved on. It happened. She didn't look at it. There was a breach. Full stop. Next page. When we talk about validating, we're not trying to say what she did was lawful in November. What we're doing, surely, is looking at whether or not the statement from the time it was revisited was adequately revisited going forward. So rearguard and validation are perhaps words that are unhelpful.
So the question is whether relief should be granted in those circumstances.
Yes.
So if I rephrase the proposition I was struggling to formulate, it may be more difficult to obtain relief
Yes.
if there's just a breach at the formal adoption stage, whereas previously, when the plan was being prepared, the 5 environmental principles were fully taken into account.
Yes. And
So
again,
that perhaps goes to show also a well-established truism that whether there's a breach of this, the relief that the court may grant is heavily fact-dependent.
yes, my lord.
And here we're dealing with a policy which was being formulated and looked at by Minister Rowley in October when the duty didn't even apply.
Yes, my lord. Yeah. And on that fact dependency, other factors such as the nature of the policy in question would clearly be relevant as well, because this duty applies to almost any policy formulated by a minister, whether or not it bears on the environment or not. And so, in a case where a policy was being formulated which had very little to do with the environment, a breach of a certain character may well not lead to the necessity of a remedy, because it would be easier to see that the breach made very little difference. And so those factors are also, the nature of the policy in question is also going to be relevant.
That sounds like a section 31(2)(a) argument,
Well, that's what my learned friend puts in the respondent's notice
which we
expressing.
don't always reach, but
Remedies are discretionary anyway. Section 31(2) imposes a duty on the court to refuse a remedy in certain circumstances, and that may be one way of analysing it. It may be an unhelpful way of analysing it when there has actually been a breach and there's nothing you can do about it. There was a duty which was breached, and you're now seeing whether going forward it is appropriate to grant a remedy going forward. But it may be that you just rely on the principles that had existed long before Section 31 was amended.
Yes, well, I'll endeavour to address it on both fronts. A very helpful exchange. What I was trying to address was, as the point was articulated by my Lord Justice Holgate, that the focus of both the duty in the statutory terminology and in the plan itself on the formulation of policy will be relevant to the subsequent question of what the court does about the breach. And so if we have a look at the EPPS, the Environmental Principles Policy Statement itself, starting at page 6, I just want to highlight some of the phrases within that emphasise the importance of the formulation of policy. In the first paragraph, at 4 lines down, the policy is to deliver a system that places environmental considerations at the heart of policy making across government. In the final sentence of the second paragraph, we're told we can also ensure the environmental principles are used consistently across government to guide policy making whilst supporting innovation and economic growth. And in the next paragraph, the 5 principles play an important role in tackling climate change. It is not prescriptive in dictating the outcome of any application of the environmental principles. Instead, it aims to provide ministers and those developing policy on their behalf with the space to use the principles to enable and encourage innovation. This approach will ensure that nature and the environment are proactively designed into the policy-making process. So, another phrase, designed into the policy-making process. And then over the page, at page 7 of the bundle, the purpose of these principles is to, the second paragraph down, the purpose of these principles is to guide ministers and policymakers towards opportunities to prevent environmental damage and enhance the environment. And then policymakers should consider and use the principles iteratively from the outset and during subsequent stages in policy development. They should identify the potential environmental effects, positive or negative, and use the principles to inform and influence the design of the policy. And then at the top of page 8, the policy statement sets out how ministers should interpret and proportionately apply the principles so that they are used effectively to shape policy to protect the environment. So that's shaping policy phrase. At the foot of 8, policy making, the legal duty to have due regard to this policy statement applies to ministers when making policy. Policy can be broadly understood as an intended course of action adopted to achieve an objective. And then over the page at 9, is that definition in the paragraph below the bullet points is making policy includes developing adopting, revising or repealing policy. Under the next heading, applying the principles on page 10, a policymaker's second sentence should take a holistic common sense approach when thinking through the potential environmental effects of a policy option, which could be positive or negative. They should consider how adjusting the design in the early stages of policy development could result in greater environmental protection. And then
I'm finding it difficult to see how, for example, that sentence applies in this case, because it's giving guidance for a time when the policy is in force. Sorry, I beg your pardon. Yes, the policy is in force. I mean, there's no challenge in this case that this guidance wasn't complied with in relation to the steps taken before formal adoption.
the relevance of the steps taken was, as my Lord articulated on my behalf, was to look at whether the remedy that the court should be granting is one that requires the reconsideration of adoption. In other words, is what's been done in March adequate to remedy the accepted illegality in December?
Or alternatively, if we stop treating the application of the policy statements as an assessment of the policy, isn't the question whether the assessment that was done as to what policy should apply from the date of the assessment going forward was adequate? If it was adequate, why do you need to grant a remedy?
Well, we also challenged the adequacy of that
Yes,
statement.
that's a separate issue, yes. But if it was adequate,
yes.
I
But
don't see
what I'm trying
why
to...
we're worried about whether the
Yeah.
earlier illegality was remedied. It can never be remedied. It happened. The
Yeah.
next question is whether the assessment is adequate to ensure that going forward, the written policy statement, the written ministerial statement, adequately reflects environmental concerns.
Yes. What I'm trying to advance is the touchstone of adequacy. How do we decide whether what was done is adequate? And that has to have relevance to the statutory term in the duty, that the duty is when making policy. And so if the nature of the breach is that there's an accepted breach upon adoption, when one comes to the revisiting in March, is all that's required to assess the policy as it presented itself to the minister on the 13th, or is what's required to apply the duty to the making of the policy, does that require the minister to consider the development of the policy as an option as well?
I hadn't noticed that point being taken in the pleadings.
That's the response to
because that would be to require the policy to be applied in relation to stages of the making of this particular policy, its development, when the duty wasn't in force.
Well, we're not applying it to the stages of development when the duty wasn't in force.
Well, you talked about the development of the policy. Well, the policy pretty well been developed by October.
Pretty well, but not.
There was just one sentence missing, I think.
I think it's three. We'll go to that.
Okay, we need to see that. Yeah.
But it's that question of what is it that the minister was actually required to do in December that bears on whether what is done in March is sufficient to say, well, it was adequate, to use my Lord's term. There's no need for any further remedy.
And it's your submission that in December the minister had to consider how the policy had developed in the past. That's what you seem to be saying.
Yeah. The duty on the minister at that point was one that bore on the development of the policy. That's what making means, the developing and adopting of the policy. She was looking at a policy that had been developed, and so needed to look at the development of the policy when making the decision whether to adopt it.
Go right back to square one.
No, to the development. So,
well, what does that mean?
Well, in particular, it focuses on the evolution of the policy.
Well, that's what I'm asking you about.
Yeah.
That could include going back to square one.
The duty does bear on the development of policy. it wouldn't rule out going back to square one. It doesn't necessarily oblige that.
Well, that's the critical question, because we're talking about obligation here.
This minister, whenever it was it December, had to decide whether to adopt the policy. That's what she was deciding. And she didn't do it lawfully. But she wasn't a judicial review report saying, have they done everything all along in the right way? She was deciding whether to adopt policy. You've never challenged the development of the policy. You have challenged the adoption of the policy. It seems to me that the position that you get to then is when the error was identified, and when the minister then decided whether to maintain and enforce the policy, even though things have gone wrong earlier on, is whether the decision to maintain that policy had due regard to the environmental principle statements.
Yeah.
The minister isn't actually, like the High Court, conducting a judicial review and marking what was done. The minister is trying to see whether or not that policy will achieve that which the government wishes to achieve.
Yeah, so the minister at the point of adoption has to have regard to the environmental principles policy statement, and when she looks at that, she looks at this text that we've just been having regard to, which is directing her to an approach that ensures that nature and the environment are designed into the policy, that the principles are used to shape policy. Those are the considerations that she needs to have in her mind in order to have due regard to the EPPS. How have the principles shaped this policy? How can they shape this policy? That's what due regard to this statement involves.
And that, to be fair to you, is set out in paragraph 2 of your statement of facts and grounds, where you acknowledge the admission that had been made on behalf of the minister. And you then say, 5 lines up, this exhibits a misunderstanding of the scope of section 19, which states in terms the duty applies to the minister when making policy. And so it comes down to a factual analysis of whether that was discharged or not.
Yes, well, we know that the duty wasn't discharged. The only issue we're really dealing with now is whether it was enough to discharge it in March.
Absolutely, that's what I was talking about, when it was done again.
Yeah, when it was done again, we also challenged that on. So, before we move on from the duty itself, the Office of Environmental Protection has set out its position, again reflecting the statute and policy position itself on the proactive consideration of the policy making process, which it sets out at paragraph 7 of its as an argument.
Sorry, paragraph 7
of the Office of Environmental Protection's replacement skeleton argument. And it refers to the explanatory notes to the Act to reinforce that perspective, that the object of the Section 19 duty, in the emphasised line at the bottom of the page, paragraph 7, is to ensure nature and the environment are proactively considered in the policy making process. That's reflective in any event of what the policy itself says. And at paragraph 12, they set out the Office's submissions on the wording of Section 19 and refer to a government response to the Section 19 duty in the final line, that it's more than a process requirement or tick box exercise, but a requirement for policymakers to pay proper heed to environmental matters in the policy making process. And then at paragraph 43 of their submissions, their submission is that carrying out an assessment retrospectively, it will not be possible to have meaningful due regard to whether environmental effects will be different to other areas of policy, so they can be considered or carry out additional research.
So does that mean once they've made a mistake, that's it? It must stop. Everything must be scrapped and you must start again. What do they mean? If the assessment is carried out retrospectively, it will not be possible.
Well, I'll let them speak to what they mean if that's. I think that's.
And what is your submission on that?
Yeah.
Well, I accept in principle that in some contexts, retrospective assessment is capable of fulfilling the duty.
But it didn't occur in this case.
But obviously,
Yeah.
I would take the point it didn't occur in this case.
Just to complete your submission.
Yes.
Yeah.
And what I've been trying to front load is that question of whether retrospective analysis or assessment does discharge the duty is to be assessed by considering the nature of the duty and the policy itself, and that is a duty which I've been setting out, which also applies to the process of formulating policy. Can I then take the court to the factual background, which I'm going to take largely from the written statement of Mr. Palmer for the respondent department, which is in the supplementary bundle at tab 8. He is the Director of Building Performance in the Department for Levelling Up Housing and Communities. And beginning at paragraph 8 of his evidence on page 53 of the supplementary bundle. He explains the background to the Future Homes Standard, which is to reduce CO2 emissions to 75% lower than those built to 2013 standards, and avoid the need for future retrofit of new buildings to make them zero carbon in use, through including use of fossil fuel heating in most new homes. And then in December 21, there was an uplift to the National Energy Efficiency Standards for new buildings, which came into force in June 22, which delivers around 30% lower CO2 emissions compared to homes built to the 2013 standards. Then at paragraph 13, he sets out the first set of salt cross proceedings. This is the first of the two related rights community action claims, which was about the Salt Cross Garden Village Area Action Plan, which applied a 2015 written ministerial statement that stated local planning authorities and qualifying bodies preparing neighbourhood plans should not go beyond level 4 of the code for sustainable homes. The upshot of that challenge was that Mrs. Justice Lieven confirmed that the previous WMS, her judgment, the previous written ministerial statement, was in effect out of date, because it said that local authorities shouldn't go beyond a level of energy efficiency which had then been exceeded by minimum requirements in the building regulations.
It was related to the Code for Sustainable Homes, but that was on the way out, and by then in 2022, the 30% uplift to Part 11 of the building regulations was in place.
Yes.
Is that the point?
Yes, and so the instruction not to exceed the level in the Code for Sustainable Homes no longer made any sense, where the minimum was higher.
Was already greater.
Was already greater than the instructed maximum, and so she said that was out of date. If my Lord wants the reference to that policy, it's at tab 22, page 118 of the supplementary bundle.
Sorry, which policy? The Code for...
no, the previous written ministerial statement.
Sorry, I beg your pardon. 2015, it's at...
tab 22, page 118.
Thank you.
Supplementary bundle. And it's relevant at this stage the court may have noticed that there was a provision in the Deregulation Act 2015 that sought to disapply the relevant provisions of Section 1 of the Planning and Energy Act 2008 in respect of new homes only, not all buildings, but it's new homes. We'll come to that underground too, but that was never brought into force. That's what the reference is to in this department statement. And so Mr. Palmer says that that claim, the rights of community action one, illustrated the need for a new written ministerial statement. At paragraph 14 sets it out that the proposal for the WMS was also in response to concerns raised by house builders that varying local energy efficiency standards around the country were negatively affecting their ability to build houses. At paragraph 16, there's a decision not to amend the Planning and Energy Act as explained, which reflected the fact that the majority of respondents were opposed to restricting local planning authorities' powers to set higher energy efficiency standards for dwellings. And then at 25, Mr. Palmer's statement, the optional framework proposal was not taken forward by Minister Rowley. The Minister's steer was that the WMS to state that LPA should stick as closely to the current standards as possible and requested an option for how that could be done. And so then we have the first advice, which is disclosed, the 17th of July 2023 advice to Minister Rowley and the Secretary of State to publish a new WMS. The advice made clear that although the intention was that the WMS should encourage plan makers to adhere to the current standards to minimise housing supply impacts from disruption, we would still wish to allow innovation and ambition where viable, particularly where the future home standard is not in force, to not unlawfully prevent LPAs from using their powers, and to avoid being seen to conflict with government's commitment to ensure planning policy contributes to climate change mitigation as fully as possible. That is in tab 31 of this bundle, page 165. If we mark the witness statement, we'll go back there, but just to see the document.
So that's the 17th of July document.
Yes, my lord.
Thank you.
Tab 31, page 165.
And what do you want to show us from
The
there?
recommendation was to use the WMS to strongly urge plan makers to consider viability in the forthcoming FHS, set criteria conditions for areas to meet proposing policies that exceed national energy efficiency standards, and to publish the WMS alongside the FHS consultation. The background is explained at 1 and 2, and then over the page at 166 were two options. If my lords would read option 1 and option 2. And so option 2 was to state that plan makers are unlikely to need to go beyond building regulations, but should they wish to do so, set new policy criteria in the WMS. So that was the first incubation of what emerges into the written ministerial statement ultimately. And then the outline draft.
What's the difference between option 1 and 2? Is it mainly a difference of emphasis?
Yes.
Because they're both tied to the FHS and viability. It's just that 2 seems to be a bit more emphatic.
Option 2, I think, is the policy set new policy criteria in the WMS.
Well, that's what I mean by emphatic. It uses criteria to related to the same 2 factors to say when an exception might be acceptable.
Yes. So I think the first option is an urging not to go beyond the standards, to keep them standardised. But the second is to say...
But if you do, consider carefully viability in FHS uplift.
Yes.
And those same 2 factors are referred to in option 2, but as criteria to define when an exception in terms of the policy might be acceptable. Have I understood correctly?
Yes.
Okay.
And so it would be stated as a criterion, for example, on viability, which would then provide a more
And indeed, in the explanation, just below the bold type, to limit the likelihood. So even then, that's not in stone. It's
Yes.
only policy, but it limits the likelihood of non-viability.
Yes, and would give a more tangible basis for examination inspectors to reject policies that were felt to infringe viability. So rather than a mere urging to think about viability, if it was a criteria, the option 2 suggests itself as a mechanism by which the Secretary of State, through her inspectors, could then say the plan doesn't conform to national policy in that respect.
And in a sentence, how is this helping us to decide the 2 issues that arise in this case? Is this going to help us how?
I'm just explaining the formulation of the policy in the background. It's an important part of the case. This doesn't direct barely. It doesn't.
So the 2 policy options in July 2023, right?
Yes. Paragraph 28 explains the minister's paragraph 28 of Mr. Palmer's and then paragraph 29 explains that following that July option, revised text was then sent to the minister on the 5th of October 2023, and we have that at tab 33, page 175.
Could you give me the reference again?
So tab 33, page 175 of the supplementary bundle.
Thank you.
This is, it's not headed, but it is the October the 5th, 2023 draft WMS that went to Minister Rowley.
It was cleared for publication,
And was cleared for
but
publication.
not published.
But not published.
Yeah.
And then revised. And I'm going to help the court in a moment with where the differences lie between this and the published version. But just to fill in the gaps in time, then we're told at paragraph 36 of Mr. Palmer's statement, the intention was to publish as soon as possible, and it was agreed with Baroness Penn's private office that a submission would be sent with the background to the WMS so that she could review the matter. That was sent on the 5th of December. She was informed that Minister Rowley had approved the WMS for publication. And then at 37, between the 28th of November and the 11th of December 2023, further minor changes were agreed to the right-round version of the WMS in cross-government discussions. The changes did not alter the fundamental intention of the WMS, but added lines to make clear that the Secretary of State may call in planning decisions in some circumstances in accordance with the Secretary of State's current published policy on doing so. And then following cross-governmental agreement, Baroness Penn's private office requested the DLUHC's parliamentary team to publish the WMS on the same day. That's paragraph 38. So to understand then what was published, we have at the core bundle, tab 22, page 304 is the December 2013 WMS.
So we're comparing tab 33, are we, of the
Yes.
SB with tab 22 of the CB?
Yes.
Thank you.
And so we'll see on page 304 the adopted WMS begins as a government, and we see that as the first substantial paragraph of this, and similarly paragraph 2 follows in lockstep, and then paragraph 3 again as between the two is unchanged. And then
There's no change at all in text, is that right? Down to, I haven't checked this myself.
down to net zero ready homes on paragraph 3, yes.
Thank you.
And then there's an identical first sentence of the next paragraph. The improvement standards already in force, alongside the ones which are due in 2025, demonstrates the government's commitment to ensuring new properties have a much lower impact on the environment in future. In this context, the government does not expect plan makers to set local energy efficiency standards for buildings that go beyond the current or planned buildings regulations. And then there's a new sentence in the adopted WMS. The proliferation of multiple local standards by local authority area can add further costs to building new homes by adding complexity and undermining economies of scale.
Was that foreshadowed in the ministerial advice, or the advice to ministers in July 2023? Was there a reference there to complexity and additional cost?
That line is entered as a result of the right round between the 28th of December
Okay, so it
and
came because ministers...
so 28th of November and
Yep,
5th of
okay.
December. So that's come in that window.
Mm.
And then
My Lord's question is, if you go back to October before the right round, was this sort of consideration being raised by officials?
in substance as opposed to the specific words, my
Yeah.
Lord
Yes.
means.
Oh,
Sorry.
right. So the substance had been raised before then.
I would need to go back, but I think that would be right, that in substance, yeah, I just want to check, but I think the point is probably features elsewhere. I can't off the top of my head find exactly where, but yes.
Yeah, so that's one new sentence.
Yeah, and then the second, and then it says, then we go back to the same text at any planning policies. Proposed local energy efficiency standards for buildings that go beyond current or building regulations should be rejected at the examination if they do not have a well-reasoned and robustly costed rationale. And then the 2 bullet points are the same. And then in the adopted WMS, there's then a new paragraph, which is where plan policies go beyond current or planned building regulations, those policies should be applied flexibly to decisions on planning applications and appeals where the applicant can demonstrate that meeting the higher standards is not technically feasible in relation to the availability of appropriate local energy infrastructure, for example, adequate existing and planned grid connections and access to adequate supply chains. So that's added. And then...
Sorry, catching up with you, I hope I've understood correctly, that's taken to refer to plans already in existence as opposed to ones which are being drafted and going through examination.
I think what that's trying to do is get to the question of individual planning applications as opposed to plans. So whether drafted and in existence or whether they come into existence. Once those policies are in existence, it's saying decisions on planning applications and appeals should apply those policies flexibly.
Where the applicant can demonstrate that meeting the higher standards is not technically feasible.
Yes, so...
It's not a general flexibility, that it's flexibility where the applicant can show, look, it's just not technically feasible.
Yes.
Yeah.
So whether the policy was adopted before or after this WMS, the applicant has a clear policy guide as to what they need to show to say, well, we can't meet those higher energy standards. And then the next sentence is common to be sound. Local plan policies must be consistent with national. Sorry, they're not quite the same actually. That's been changed. Sorry, so that in fact on the.
Well, it looks to me as if some of what's in to be sound features in the paragraph that you've just told us was new.
Yeah. So there's a.
It's not a new paragraph then. It's just that the bit about technical feasibility is to be applied now to plans.
Well, yes.
Or the plans, the local energy efficiency standards. It seems to be the
same
way of saying
idea.
the same thing.
Yeah, I mean it's a technically different point, but it's the same rough idea.
Yeah.
The point in the original was that the policies themselves should make that clear. The point in the new one is that where you've got policies, the applicant can rely on that point in the application documents as an evidential
As it says in the original. So would it be fair to say this is not new in substance, this paragraph?
Well, it is a difference of
The words are
technical
different,
nature.
black and white words on the page are different, but is it new in substance, in reality?
It's a technical difference.
Well, I'm not understanding what the difference is.
So in the
As a
original,
matter of substance, which is really, I think,
the
what we're
original,
concerned with.
in the original, it concerns the soundness of local plan policies. So it's concerned with examination of plans.
Okay.
In the WMS, it's concerned with planning applications.
Applications, yeah.
Yes, but the reason why it wouldn't be sound is the same reason why they've got to be flexible in applying the policies. The point is that if somebody can show that it's not technically feasible to meet the relevant higher standards, then there should be flexibility. Whether you do that by building it into the policy, so the policy or the local plan policy is sound, or whether you talk about individual applications, it's the same central theme, isn't it? That when you come to an individual decision, if somebody can show it's just not technically possible, then you've got to bear that in mind.
Yes. In the original, if that is established, then well, in the original, the policy should make that clear. In the subsequent,
It's the decision.
the decisions that has a broader effect, because as my Lord Justice Holgate adverted to, it would affect existing plans. So various local authorities, my Lord, would have seen already have plans in place that require higher standards. As now drafted, the written ministerial statement would require imposes the flexibility criterion in relation to applicants in those local authority areas, Cornwall, Bath and North Somerset, etc. As the October version drafted it, it would only be for plans that are coming through the examination process. So there's a broader ambit to the to the
Can I
versions
see if
drafted.
I've understood this?
Yeah.
Can we call it for short the flexibility point?
Yes.
As drafted in October 2023,
Yeah.
the WMS said the flexibility point should be in the policies
Yes.
coming through in local plans. What the adopted WMS does is to say, well, whether or not it's in the policies,
Yep.
this is what national policy is saying should apply when you come to decision making on individual planning applications. So in a sense, it's stronger. It's saying whether or not
Correct.
it's managed to get through as a flexibility criteria in the policy, this is what national policy requires.
That's
And by
exactly
the way, that applies to existing plans as well as to ones coming through the system.
Yes, my Lord.
So if anything, it's more in your favour.
Well, I'm not advocating for one way or another what the policy should be, or
Sorry,
yeah, but,
sorry, no, it's not quite right. It's applying more. Yeah, anyway.
but it
Let me
extends
make a
the
note.
reach of the written ministerial statement further than the October version. We'll put it that way.
It's the same point as my Lord has observed in substance, but it applies to plans whenever adopted and whether they contain flexibility or not.
Yes.
Sorry.
And avoids the risk of local authorities having to revisit all their plans.
They wouldn't need to incorporate this
Yeah.
to that's true.
But it would be very odd if a new planning coming through that had to be assessed for soundness would not be sound if an individual application could be rejected, even if it was not technically feasible to meet the higher standards. But this different local authority who put its plan in place earlier could reject an individual application because there's nothing in the policy about it not being technically feasible, and they're not going to apply that to the particular application. The reality is, isn't it, that however the ministerial statement is expressed and what it's grappling to, surely the key concept is it's recognised that when development occurs, if it's not technically feasible to achieve the relevant higher standards, you should be flexible and you shouldn't turn that down automatically. That's what it's saying.
The difference is
you can find out how it applies differently, but that's the core of it, isn't it?
yes, but it's an important difference, because where you've already got a plan in place that doesn't have a policy that sets that out, the written ministerial statement then becomes an other material consideration,
Yeah.
which allows departure from the plan as drafted. That's different to encouraging plans to be drafted henceforth in a certain sort of way.
I appreciate that, but in reality, surely the fact that you can't technically achieve what is in the plan would be a material consideration and a good reason for departing from the plan, whether you've got a ministerial statement to back you up or not.
It could be, it would, but obviously it has more weight behind it if there's a written ministerial statement that says so. So if there's a written ministerial statement that says it, it's going to be difficult for any decision maker not to have regard to that. If there's a policy document that's been adopted and been through examination and says these are the standards, and the developer comes along and says they're not viable, it's going to be a harder task for the developer to get through that.
Is I think what they're driving at, isn't it?
Sorry, I didn't hear that.
Technically feasible is what they say, not that the standards aren't viable, but that it's not technically feasible on that application. Anyway, I don't think we need to spend time on it.
Okay.
One does wonder whether this is the sort of thing that if Baroness Penn had read the EPPS
Yes.
in December, she would have said, oh heavens above, we better strike out and go back to the original wording.
Well, at the moment, I'm just trying to make sure the court understands fully the implications of the differences so that the facts are
So in part this
straight.
is different, yes, this paragraph is different in part.
Yes.
Just before we leave this, if you go back to the criteria, which as you rightly say are the same in both documents, criterion are directed at plan making.
Yes.
And there's no rocket science about this. Viability in plan making has been around for quite a time.
Yes.
And when you look at viability, the effect of policies on development, you're looking at development generically within a district. You're not looking at case-specific, site-specific viability. That's what the criteria is referring to. But then the extra words that we've been discussing are saying, well, beyond that, even if the policy has got through examination and the viability test has been satisfied, we accept there may be some cases where there's a particular site-specific viability problem,
Yes.
which should call for flexibility.
Yes.
Yeah. Good, thank you.
And so, to come back to my summary point, my lord, the reach of the adopted WMS is greater than the reach of the proposed in October. There are more scenarios in which a developer could point to the policy very specifically and say, in this case, I'm an exception to the existing energy efficiency standards, for example. It would be more helpful to a developer who has a viability problem than the proposal was in October. And then the penultimate paragraph is added, which is the intervention paragraph. The Secretary of State will closely monitor the implementation of the policy set out in this WMS and has intervention powers provided by Parliament that may be used in respect of policies in plans and or development management decisions in line with the relevant criteria for such intervention powers.
Anything wrong with that, though, in terms of the EPPS? That's simply saying the Secretary of State will monitor it and use any powers provided by Parliament to support policies.
I'm not here to criticise the substance of the policy.
No, but in terms of your case, you said that you're building up to a situation where you're saying no matter what the Minister did in March, he or she couldn't correct what had gone wrong, but in reality, is there anything much in inverted commas to correct in that last additional paragraph?
Well, what I'm trying to do at the moment is just understand what the development involved in December. So what we've seen is that we've seen the evidence of Mr. Palmer. Those additions were added between November and December as a result of an interdepartmental process, presumably involving other ministers as well. And we know that none of those developments of the policy, to use the word in section 47, the making of the policy, none of that was subject to the section 19 duty.
And I want to know whether it's a real point or a tick box point, to use your phrase. I'm wondering whether that new paragraph could conceivably, is it your case that it might conceivably have been different if Baroness Penn had looked at section 19, which had said, oh no, we would closely monitor it, not in the light of the EPPS. And no, we won't use the powers given by Parliament. I mean, she couldn't have said that, could she? So is that paragraph really relevant?
Well, what those handful of amendments have done is to emphasise the discouragement from adopting standards that go above existing energy efficiency requirements. That's what each of those changes seeks to do. So that direction was a result of the interdepartmental consultation that we're told occurred in the latter stages of November and the early stages of December.
This emphasises the disincentive to adopting higher standards by local authorities.
Yes, that's what they do collectively, is to say the proliferation of standards was the first one, can cause viability problems. If you do adopt them, then policy now is that there's this flexibility criterion around viability in any event. So the force of that policy may well be weakened anyway. And examining inspectors and the Secretary of State may use intervention powers to overrule you. So it's giving a clear steer to local authorities that if you do adopt these policies, they may in any event not be very easy to apply in practice, and the Secretary of State may reject them on examination or may use intervention powers to overrule you.
The reference to examining inspectors, sorry, that in the final...
That's in the previous page, isn't it? The rejected at examination is the final sentence on 304 of the paragraph above the bullet points.
Yes, but that was in the original.
Yeah.
Sorry, that was in the
And it's a
original.
statement, it's a statement of the obvious anyway.
But it
I
follows
thought it was
on
the
from the
previous
proliferation
sentence.
of it. Anyway.
Was new.
Sorry, okay.
I thought it was the previous sentence, the proliferation.
Yeah.
It was moved, yes.
I thought the rejected audit examination was already in there.
It was.
Ah, right. So that's okay.
So, what might be called colloquially the guts of the policy, at the last paragraph on page 304, apart from that one sentence on proliferation, was subject to the October 2023 non-statutory EPPS assessment.
Yes.
But, so when you say something, you now understand what wasn't. Okay, thank you.
If we go back to the statement of Mr. Palmer, which is at tab 8. Paragraph 38, we're told the private office requested the team to publish the WMS. Elsewhere in the case for the respondent, that's taken to mean the minister adopted it. We haven't got a document that indicates that that's the case, but that's the way the case is put for the respondent.
And there is case law saying that if there's nothing else to indicate the day on which the policy took into force, the day it's published is taken as the day it came into effect. So,
On the 13th of December.
yeah.
So there's an acceptance that no EPPS assessment was done when the decision was taken. It follows that there was no EPPS assessment of the form in which the WMS was published.
Save for what happened in October, non-statutory.
In the form it was in October, yes. Yes.
And do you accept that the EPPS, although it was non-statutory, had this requirement been in place, save for those paragraphs or sentences that you've shown us, had there been a duty to have regard to an EPPS, it would in fact have been met?
No, we don't accept that.
Well, the October one wouldn't have met it?
No.
Ah.
Because the October one doesn't have regard to the 5 environmental principles set out in the EPPS, which was published by that point.
Right.
And if we just take up the respondent's skeleton argument to understand the way the concession on illegality is put by the respondent, it's paragraphs 6, 53 and 54.
In the core bundle.
Yes, in discussing argument for the respondent. That's tab 2 of the core bundle. So paragraph 6 of that.
Which page?
Page 32, Mo.
Paragraph
6, my lord, at the bottom of page 32. In relation to ground 1, there was an oversight in that the minister who actually approved the final version of the 2023 WMS for publication was not presented with information on the EPPS. To that limited extent, unlawfulness is accepted. However, for the reasons developed below, it was not an error that could justify quashing the 2023 WMS or even a declaration of unlawfulness. And then at paragraph 53...
Well, you just read something. I still can't find that sentence on page 32.
Well, it's on page 28. I was going to raise this.
I'm sorry.
You said 32, and
yes.
I can't find it on 32, but it's on paragraph page 28.
28 at the bottom. Paragraph 6, the last line.
Right, okay. Yeah, okay, I've got it now. Sorry.
I'm sorry, that page reference was wrong.
And then 50.
Paragraph 53.
Thank you.
Which is page 41. It's accepted that in promulgating the 2023 WMS, the relevant minister did not consider the Section 19 duty and did not have sight of the October 2023 EPPS analysis that informed the WMS. To that limited extent, the minister who approved the policy as finally adopted did not have due regard to the EPPS in breach of Section 19.1 of the EA 2021. However, that should not be taken to imply that due regard was not given to the EPPS in developing and maintaining the WMS, nor does it mean that the admitted unlawfulness is of great consequence. In the particular cases of this circumstance of this case, import should be afforded to 1. The due regard given to the EPPS where the text of the WMS was approved by a different minister in October 2023, and 2. The due regard given to the EPPS in the development and design of the FHS, which is closely associated with the 2023 WMS, and 3. Further EPPS analysis carried out in February and March, where due regard was given by the minister. It's the defendant's or the respondent's position. So that concession doesn't go so far as to accept that the development of policy in the period November to December also didn't involve due regard to the EPPS. But that plainly is the case. Whatever one makes of the weight or materiality of the differences, that plainly is a feature of the illegality that led to the minister's failure to have due regard as well. So when they were considering those amendments to the October draft that we've looked at, there was no EPPS analysis undertaken either at departmental or ministerial level of those amendments. And the significance of that in the context of this duty is not simply that some assessment wasn't undertaken, it's that the formulation of policy didn't have regard to the principles. And what the document, the EPPS document itself seeks to emphasise is the importance of building those principles into the design, into the options, into the consideration of formulation of policy. And so that stage of formulation, neither at the ministerial moment of adoption nor in the course of it, was subject to the EPPS duty.
I'm not following that. They did the October thing, they invited comments from other ministers, by the sounds of it, and those came back, and then somebody had to sit down and decide whether or not to take those changes on board or not.
Yes.
And they weren't taken on board, whether you call it the development or the decision to adopt. The thing that occurred, that shouldn't have occurred, is the making of those amendments without a Section 19 duty. I can't see that it really matters whether you call it developing or making the policy. What happened was between the end of October and publication of the policy, the Minister taking the decision on the content of the written ministerial statement didn't have regard to section 19.
Yes.
I can't say that there's any
Well,
more to it than that.
Yeah, I mean, it's because it goes to the heart of the nature of the breach. It's about what the duty is all about. So the duty is all about having regard to these principles in the statement. What the statement tells us is that the principles are intended to affect the design of the policy. So it's different in that respect to the PSED, the Public Sector Equality Duty, where typically you do an assessment once a policy's been formulated. This duty is all about the formulation of policy. And
Well,
so
I don't understand. So are you saying that the people who write in, having been asked to write in, must also do an EPPS due regard? Or is it just the Minister, and obviously the civil servants, I imagine, have to process the proposed write-in,
so
having regard to an EPPS?
Well,
what are you saying? This
there may be different ways you could do it, but the minimum would be that the Minister, when adopting the policy, would be apprised of the development of the policy and the way in which that the EPPS principles bear on those elements that have been developed. That's what the EPPS before the Minister should have done, because
let's be practical. In October, Minister Rowley deals with it.
yes,
For some reason, presumably he's been reshuffled and Baroness Penn takes over. And between the end of October and the 13th of December, various things come in for changes to it. And Baroness Penn presumably has to sit down at her desk or whatever and consider those changes and decide whether or not to alter the words in the written ministerial statement. And what are you saying, that she doesn't just consider those and consider the EPPS to see if those changes will improve it? She's got to do what? She's got to have an additional document telling her how Minister Rowley had arrived at the original draft, and she's got to satisfy herself.
no, she doesn't need an additional document doing that. But
Well, what does she need to do then?
Well, the duty is to have regard when making, which includes developing the policy to the EPPS.
Well, she wasn't involved in the developing until the end of October, and the duty didn't apply anyway.
Yes.
So there's no breach there. So what was she supposed to do other than consider these changes and consider the EPPS?
Yes. So she was. That is what she was required to do, was consider the policy, how the policy had been developed, and
Well, what does
the
that
way in
mean?
which...
What period of time over the development of the policy was she supposed to consider? I mean, what has she got to look at? Are you telling me she's got to look at everything that's happened from the July 17th ministerial advice up to October? Or does she just look at what's now proposed to be changed and see whether those changes are good or bad in the light of the EPPS? You say she's got to look at the development of policy. What does that actually mean in practical terms, is what I'm driving at?
It means at least bringing her mind to bear on the changes since any previous lawful consideration. Now, for the moment, I'm not dealing with the lawfulness of the October decision, but at least it needs to do that, because the duty applies to the making of policy. But obviously, that would be very limited and not very concordant with the way in which the policy actually involves or asks the development of policy to be analysed. And so that might be some minimum legal standard, but the proper approach would be to apprise her of the way in which the environmental principles in the policy informed the development of policy.
You say that again. So is it unlawful for her not to have gone through the advice in July and the steps that Minister Rowley took place, or is it not unlawful for her not to have done that?
The advice that she's given in December doesn't need to specifically advert to July, but it does need to explain to her how the EPPS, the environmental principles within the policy, have borne on the development, the making of the policy, because that's what the duty is.
So the advice in December must explain by reference to the EPPS what the significant steps taken hitherto.
So when you go to the EPPS document itself, there are 5 environmental principles in there. And what the EPPS document tells ministerial decision makers is that they need to assess policies against those in the formulation and design and shaping of policy. And so the minister needs, in order to have due regard to the duty, to understand how those principles inform, shape, design the policy. It's not merely an assessment tool. It's not, here's a policy we've developed, how does it match up? That's the PSED common approach. This is one which integrates those principles into the formulation and design of policy. That's what she needs to do.
I'm trying to get away from words. I'm trying to find out what she had to do.
That's what I was trying to explain, is that she needs to have that set out to her presumably by a departmental official, to enable her to take that into account.
Let's see if I can understand this. The statute refers to developing, without further definition. The principles go a little further. They talk about designing policy and they talk about developing it. These are not terms of art. They're practical terms to be applied to policy making. And policies come in all shapes and sizes. There are some that are very complex. This one is relatively straightforward. It's quite short. It's not very difficult. So when you talk about design, and there are not many stages in this policy either, when you talk about design, does that refer to the policy initially being conceived, perhaps?
So to take an illustration that we've got in front of us in the evidence, because that might help focus.
Well, that's what the case is about.
That's what we're trying to do, is to find out what
in the July, two options were given.
Yes.
So the EPPS analysis would have then looked at option 1, option 2, and the way in which they match up against the environmental principles in the EPPS. And so you can see then that in the selection of options, in the shaping, the formulation of policy, due regard has been had to the EPPS principles.
Yes. Now, assuming that was done, I know you say it wasn't done.
In July, it definitely wasn't.
Assuming it wasn't done between July and October, and the options that it was done, and the options that emerged did have regard to that, and then Minister Rowley's reshuffled and Baroness Penticliffe, and all she's asked to do is look at some further wording in the policy. Is it your case that nonetheless she had to go back and reassess by having due regard to the EPPS, the initial, if you like, policy choices taken?
Yes, she does, because that's the adoption part of making the policy.
Before we get to adoption, we started off in July, the two options, and then the policy is formulated in October, is that correct? That's when it's given
largely, yes,
birth to. That it's been designed at that stage, whatever, if we have to use a label. But then the development are the changes in the policy between October and December. Is that it, basically?
Yes. Well, there's a process of development.
Simple Janet and John terms.
Yes, there's a process between July, October, further stage in November, December, and then adoption in December. And at the point of adoption, that is one component of making policy in the definition in section 47. The duty applies to the adoption.
There's no doubt that when she authorised publication, she didn't have regard to it. That's clear. We're not arguing about that. We're arguing about your insistence that it has to be development of policy in design. And in simple terms, I'm simply asking myself, is she required to have regard to these new changes to see whether these changes are or are not ones to be made in the light of the EPPS, or whether she must go back further and say, I have to look at the original policy choices that were made to which this suggested changing in the wording applies?
The duty...
No, what does she have to do? Not the duty. What do you say the duty requires her to do in practical terms?
What she has to do when adopting is have due regard to the...
So did she have to look at the original choices that had been taken, or did she have to look at the changes in wording to that?
Both.
Both. Okay.
She had to look at the options 1 and 2, the policy in October, and the changes since then. Is that it? It's a simple question.
She has to look at the process of development. That's not going to come down to don't insist on the minute requirement that the options in July are reiterated to her in some departmental
But then
briefing.
how much of the anterior process does she need to look at
Well, she needs to be apprised of
to,
it.
to be able to take a lawful decision?
She needs to be apprised of it.
Well, sorry,
It
that
could be
doesn't
some-
apprise-
doesn't answer the question.
It could be. It has to be adequate to discharge the duty.
Yes, what did that mean in this case?
Well, it would mean some form of briefing being put in front of her when she adopts it
Yes.
that assesses the development of the proposals against the EPPS.
Why is she doing that? She's adopting it, and it's been written, and all she's having to do is check the changes. I mean, she's not there like a judicial review court to see whether earlier ministers complied with their duty. She's deciding whether she wants to approve these changes.
Yeah, well, in that scenario, you're assuming the earlier process
Yes, that's the
is
hypothesis
accepted.
that we're working on.
Sorry.
Yes. Yes. If that's not right, we'll have a different argument because
Yeah.
it's never gone through the EPPS assessment.
Yeah.
But we've said, or I've said, tried to say throughout, that assuming that was validly done, even though it wasn't statutory, because it wasn't enforced, if the substance of what we had done under Section 19 was met at an earlier stage, and I had understood your answer
Yes.
to be, it doesn't matter, she's like a judicial review court, she must herself reassess the development of policy, probably from the very beginning.
On the hypothesis that in the course of developing policy, a Secretary of State has already, at an earlier stage, discharged the duty in respect of an earlier phase of development, then I accept that what she needs to do at the later stage is have regard to the policy as adopted against the principles and the policy as developed since the adequate earlier stage.
Right, that's what I was trying to get at.
I'm sorry, my lord, that I didn't follow that.
So you're going to take us to the differences, why you say the October 2023 was not
Yes.
sufficient?
Yes, I can do that. Can I do that in order after
Yeah,
just want to finish
whatever
the evidence? But I will
makes
go
sense.
back to the October decision, yes, my lord.
Because obviously that's quite an important place in your argument.
I think it would help just to get the full picture, which won't take much longer, from Mr. Palmer's evidence, and
Of
then
course,
we can go back to that. So if we go back to his witness statement, tab 8, page 60, supplementary bundle,
Yeah.
paragraph 40, he then explains that the pre-action correspondence from the claimant, which was back in December 23, alerted that the EPPS assessment that Minister Rowley had seen was not presented to Baroness Penn when she was asked to consider the final WMS for publication. In response to this particular oversight, officials prepared a detailed environmental principles assessment specific to WMS and then asked ministers to revisit the WMS in light of that assessment. So the pre-action letter itself is at tab 10, page 67. And ground 3 of that letter alleged the failure to have regard to the EPPS.
Sorry, could you get, I beg your pardon?
So tab 10, my lord,
Thank you.
page 67,
Thank you.
Supplementary bundle.
supplemental bundle.
Yeah.
And ground 3 on page 77 was the point raised in the pre-action letter. And then at tab 12, page 80, tab 12, page 80 is a holding response, and then tab 14 on page 83, tab 14 is the substantive response. And then tab 15 is the detailed response to the pre-action letter. And the final page, page 89 of tab 15, we accept that Minister Penn, who took the final decision on the 2023 WMS in December 2023, had not herself been provided with an EPPS analysis. There's then some further correspondence, and then on tab 17, tab 18, page 93, tab 18. There's reference made back there 2/3 of the way down to the 5th of October EPPS analysis report, which was carried out using the work already done for the future home standard EPPS assessment. However, we're in the process of bringing together the analysis carried out for both the FHS and the 2023 WMS to provide ministers with a more detailed EPPS assessment. And then a ministerial submission is made on the 22nd of February 2024, which is at tab 35.
Page.
Page 196, my lord.
Thank you.
And you see the redactions, and then below the first summary of the issue redactions, we recommend you revisit the WMS in light of the updated EPPS analysis and the new PSED assessment. There was also a failure to conduct a PSED assessment, which isn't challenged, and confirm that you are content for the WMS to remain as published. And recommendation below that, you revisit the policy contained in the WMS in light of the attached EPPS and PSED assessments, and to demonstrate compliance with those legal duties, confirm if you are content for the WMS to remain as
So you're reading from
page 196 under the heading recommendation, the second unredacted bullet point.
Oh yes, there it is. Sorry. Thank you.
We're told this is legal professional privilege redactions. And then 198, 2 pages on, bullet point that you revisit the policy in the WMS in light of the attached EPPS and PSED assessment, and to demonstrate compliance with those legal duties, confirm if you are content for the WMS to remain as published. So nothing's been disclosed about how that decision was made in terms of the weighing up of the decision. Nothing to show that it was approached with an open mind, a clear slate, all of those requirements of the PSED.
Nothing to show that it wasn't either. There's nothing there. It says you've got to revisit the policy.
Yeah.
In line with your legal duties, you've got to be able to confirm that you comply with your legal duties, and then we don't know the document that you was provided with. Presumably, we don't have the EPS.
No, all we know is that phrase, demonstrate compliance. That's all we've got. There's some more detailed advice we have at tab 3.
Sorry, can I just ask on 196?
Yeah.
It says in light of the updated EPPS analysis. Where's that?
Tab 3.
Oh, we do have it.
Yes, we do have.
Ah,
Yeah, tab 3.
I just thought you told me we didn't have it.
Sorry.
That's what I
We don't
asked.
have any. Tab 3.
What we don't have is what went on inside her head.
Yes.
No,
Yes.
but we do have the EPPS. I thought you said we didn't have it. I asked if we had it. I thought you told me that.
So this is supplementary bundle, page 22.
Yes, my lord.
Thank you. Yeah. It seemed you were at cross purposes with you.
So this is the EPPS analysis that's given to the Minister in February. The Environment Act 2021 introduces a new legal duty to consider environmental effects of policies throughout their development, known as the environmental principles. And then section 1, policy objectives. And I just highlight the third paragraph. When considering the environmental principles in relation to the Written Ministerial Statement, we considered the policy alongside the plans to introduce the future home standard. Homes constructed to the FHS due to be implemented from 2025 will be zero carbon ready. And then assessing the environmental effects over the page 23.
Also, we see from the preceding paragraph that the last sentence, the policy objective of the WMS is to mitigate adverse effects on delivery before the FHS is introduced.
Yes.
In other words, it's described as an interim policy. I think Mr. Nestaway describes it as a transitional policy. It's only intended to have temporary effect in any event.
Yes. And then the assessment is over the page at 23. And then court just casts an eye down that page and then to the paragraph at the bottom under the heading 2, is the environmental effect positive or negative? And the answer is there is the potential for further positive environmental effects if LPAs set higher standards than those mandated by the building regulations. Any potential benefits would be further reductions in carbon emissions occurring largely in the period between now and the time the FHS is implemented. However, this should be balanced against the potential for disrupted housing supply caused by differing standards across the country. Such disruption could lead to the environmental benefits of the FHS not being met if fewer carbon zero ready homes are built as a result of the development not coming forward. And then page 24, heading is, are there primary effects as intended, an intended result or an effect directly attributed to the proposed action, or secondary effects, indirect or induced changes? And it's explained in the second paragraph, the intended effect. The policy contained in the December 2023 Written Ministerial Statement aims to improve the consistency of application of any locally mandated energy efficiency standards in new homes. The potential effect of this could be to help secure a more robust housing supply, as developers and house builders are given more certainty of standards. And then under 4, will the policy cause environmental effects that occur once, repeatedly or cumulatively? Effects will occur cumulatively as more buildings are constructed to new efficiency standards over time, thus gradually reducing emissions. This effect is multiplied as the grid decarbonises. So this is about the FHS rather than about the WMS. We see that throughout. There's a toing and froing between the two.
But as I understand it, the judge accepted what was said on behalf of the Secretary of State, that when the WMS in 2023 refers to planned standards, that's a reference to FHS.
Yes.
So it accepts that local planning authorities that want to go further than building regs can start relying on the draft FHS.
Yes.
Yeah.
Go up to FHS but not beyond is the...
Well, subject to the other criteria. Yeah.
And then at page 25 of this bundle, is there an opportunity to embed environmental protection in your policy? Yes. At each stage of the policy development process, the proposals have been designed with environmental protection as their central objective. The future home standard, complemented by the WMS, is intended to significantly reduce the carbon emissions generated by new buildings. 2, if it's likely for the environmental harm to result from your policy, is there an opportunity to prevent this environmental damage either before it's occurred or to contain existing damage? No. Construction of the use of homes generates carbon emissions and other environmental harms, etc. Next paragraph, in the long term, the future home standard proposals have been formed on the basis they are delivering net zero ready buildings. This reduces the environmental harm caused by future retrofit work. Secondly, the proposals are designed to do this using cost-effective carbon abatement measures, reducing unnecessary material and carbon investment, which itself has environmental impacts. Our assessment is that any energy efficiency improvements above these standards would return marginal carbon savings benefits compared to the cost uplift of doing so. And then if prevention of environmental harm is not possible or proportionate, can you address the damage at the origin to avoid remedying its defects at a later date or location? And it says no. Why not? On 26. Prevention of environmental harm is possible through the policies we are proposing. the reduction of carbon emissions will have a positive net zero effect. The WMS encourages local policies to be consistent with national standards, but still provides an opportunity to implement higher standards where those standards are found to be viable and not impact on housing delivery. So what we see here is the elision between the FHS combination with the WMS and the WMS that's under assessment, because on 23...
Sorry, can you say it again?
Yeah.
Elision between...
So all the way through this document, it flits between looking at the two policies as a combination and looking at the WMS on its own. So for example, on 23, we saw, is the environmental effect positive or negative? And the advice is there is potential for further positive environmental effects if LPAs set higher standards than those mandated by building regulations. In other words, there's a limiting effect of the WMS.
So can you give us, just to help me follow what you're saying, can you give us an example of where the two policies are looked at in combination,
so,
as opposed to WMS being looked at by itself?
Yeah, so 26.
Yeah. Whereabouts?
Prevention of environmental harm as possible through the policies we are proposing. The reduction of carbon emissions will have a positive net zero effect.
Yes.
So
the next sentence of the WMS, so it goes back to, I know you say it's switching between the two.
Yes.
The next one is, sentence looks to me to be focusing on the WMS, and it says the WMS encourages local policies to be consistent with national standards, but provides the opportunity for higher standards, where they're found to be viable and not impact on housing delivery.
yes.
So it does look at other things because they're linked. Are you saying they can't look at other things? You've
No.
drawn attention to this and said, look at this. Sometimes it's one thing, sometimes it's things in combination.
Yes.
Are you building up to a submission that is shocking and unlawful? Or?
So what it does is to confuse the WMS, which is the policy which is to be assessed at this juncture in the retrospective assessment, with the inchoate policy of the Future Home Standard, and looks at the environmental impacts of the two of them taken together. It doesn't assess, it doesn't have due regard to the EPPS in respect of the policy that's been adopted in December, the WMS.
But that December WMS says, as we were told, that if you're a local planning authority, you can have a policy which goes up to the FHS in its current draft form.
Yes.
This is an interim policy. Policy is evolving. As I understand it, there's been a great deal of consultation on the FHS already, and the consultation currently underway is on the technical aspects of the FHS. Is that,
Yeah.
to a newcomer, is that broadly speaking right?
Yes.
Yeah, okay.
So the FHS is to raise the minimum standards.
Yeah.
The WMS is to limit the maximum, subject to the criteria, in most cases, to the...
Well, government, rightly or wrongly, takes the view that when the FHS in its final form is introduced, that will be enough to achieve carbon budgets and compliance with the 2008 Climate Change Act. They may be wrong, but that's their approach.
That's their approach, yes. But there's a difference between the two policies. One is to raise the minimum, that's the FHS. The WMS is to put, subject to criteria, a limit on how far you can go. So it plays out very specifically in the West Oxfordshire case.
In a very simple situation, if a local planning authority decided to introduce in its local plan a policy which requires compliance with the draft FHS, that would be in compliance with WMS 2023.
Yes.
So, and the policy is not limiting that.
No. But if the local plan wishes to set a threshold beyond
Then
future
the
standards.
two criteria that are set out in the WMS 2022.
Yes.
But there is an inevitable link with the FHS in any event set by the terms of the WMS. The FHS, horrible acronyms,
Yes.
set by the terms of the WMS.
Yes. So
I can't see what the impermissible, unlawful elision or conflation is.
So the elision is that the carbon benefits of the FHS are assessed as opposed to the limitations on those benefits that are imposed by the WMS.
But we've just been through this. The WMS doesn't stop a local planning authority from deciding to adopt now the FHS in its draft form.
No, but it stops it from going beyond that.
That's a different point.
But that's the primary function of the WMS. So in the West Oxfordshire case, the West
Yes, but your
Oxfordshire
complaint, sorry to interrupt, but your complaint was it just simply assesses the effects of the FHS. Why is that a problem?
it confuses the assessment of the raising of the minimum through the changes to the building regulations, which is the FHS. That's one arm of the policy. That will have carbon benefits across the board. What the written ministerial statement does is to restrict the ability of local authorities to go beyond that standard.
Yes.
So where they have set policies that are already net zero or want to do
Yes.
straight to net zero,
Use Letty or whatever.
well, or to use Letty, but if
Yeah.
they want to go to a net zero threshold, the future
Yeah.
home standard is short of net zero,
Yeah.
then the WMS will, in effect, prevent them from doing that.
But what this document says, and so does Mr. Palmer's witness statement, is that they've carried out modelling which shows that the environmental benefits they claim of going further in that way are marginal compared to the additional costs.
Yes.
So they have made an assessment, on the face of it, of the potential for doing better if local authorities go above FHS. Or have I misunderstood?
Well, the confusion in the document is to repeatedly assess the benefits of raising the floor as opposed to the disbenefits of lowering the ceiling. So although it's a policy document that's intended to be focused on the decision taken to adopt the WMS, i.e. lowering the ceiling, the assessment is continuously made by reference to the advantages of raising the floor, which is not the policy, well, not the totality of the policy that's been adopted.
I'm not sure I've understood that.
I thought they did that at 23, but maybe I misunderstood it. They know there's going to be a potential for disbenefits in the period up until the FHS as a result of the WMS. I mean, they can choose, local authorities, as I understand it, to go to the draft FHS standards, but they don't have to. So if they're not being allowed to move to their own standards and they choose not to go to the FHS draft standards, there could be a disbenefit because builders wouldn't be required to build the most environmentally effective housing. But that seems to be what they're saying in 23. And then they say why they think other considerations outweigh that. Or are they not saying that in 23?
Where does my... Sorry,
Well, it's the last paragraph on
Yeah.
23.
Yeah, so the way that's put is that there is the potential for further positive environmental effects if LPAs set higher standards than those
Exactly.
mandated by the building regulations. So what the WMS is doing is restricting the capacity to do that. So
Yes.
in other words, what the minister should be being told, implicit within that sentence, is the effect of the WMS will be to limit the potential for further positive environmental effects. That's the effect of the WMS
Well,
policy.
unless you design a policy as a local planning authority which complies with the two criteria,
Unless you can achieve that, which in effect we say is
which
de
with
facto.
those criteria include viability, which is obviously a matter of concern to government.
And even then you'll have the effect of the WMS of the viability
And
flexibility
also
policy.
you have to use the metric, the TER metric.
Yes.
Maybe I just don't understand enough, but reading this as an ordinary person without much knowledge of buildings and energy, I thought it was saying there will be environmental benefits if they're allowed to go up higher, which is what the WMS is going to stop, you say. But that's outweighed by other factors. So they know that anyone reading it, it's all in ministerial jargon, but anyone knowing it will see that something that might be considered environmentally beneficial will not happen if the WMS is adopted. But they say it's outweighed by other factors.
Well, if my lord looks at paragraph 4 on page 24, what is said to the minister is that
Well, that's moving on then, actually, yes, to the next thing. Yes, then they've gone back to the combined thing, yes. But somebody reading this would surely know that in the period up until the FHS, given that the WMS is stopping them going high and they don't have to go to the draft, that what they call potential benefits are being lost. Isn't it obvious for any reader?
That's what needs to. That's the nature of the policy, and my lord has that correctly.
Yeah.
My submission is that that is not conveyed to the reader on a fair reading of this, and that it's not, and that the loss of environmental benefits is not then assessed against the EPPS criteria.
But if I understood it, and I don't know anything, somebody who does know something is bound to understand it, because the people who read this will understand it, and I got it, I thought. I don't see how you can say it doesn't fairly...
Well, what it doesn't do is assess that environmental negative, as my lord's summarised it, against the EPPS criteria. There's nowhere that assesses...
And that environmental benefit is going beyond FHS? Or what? What's
yes,
that
the lost benefit would be to go beyond FHS.
And are you basing that submission on what we see at page 23 in that last paragraph, when in the second line it refers to building regulations? Is that the flaw?
Building regulations is a minimum
spelled
standard.
with a double O.
Yes.
Yeah. Is that what you mean by the flaw?
That's the flaw, yes.
Yes,
That's the legal minimum in law that all buildings...
I mean, it does depend upon when they refer to building regulations there, whether they have in mind the wording of the policy, which says regulations including planned regulations. And once you include the word planned, you include also FHS in its draft form.
Yes, but the consequence...
So it doesn't necessarily mean they're existing building regulations, despite the capital B and the capital R. It could be actually reflecting the wording of the policy.
But even then, my lord, there is a negative environmental impact of the WMS.
Of course, because it's not doing as well as local planning authorities said, local planning authorities who set higher standards than FHS.
Yes.
But elsewhere in this document, it says that cost-benefit analysis is being carried out, modelling is being carried out, which, according to the authors, reduces marginal benefits by going further, taking into account also the cost of doing so.
But what it doesn't do is then analyse that environmental negative in the terms of the environmental principles
Well, in your pleading, you only rely upon 2 out of the 5 anyway. The first 2.
Yes. The integration.
The first one is the integration point.
Yes.
And the second one is the prevention of harm point. So we're all in the same territory.
Yeah. But it doesn't go on to do that analysis in this document of the harm.
What do you mean it doesn't analyse harm? I'm just looking at the end, section 5 now. We have identified at page 28 the following environmental impacts. Plan makers have the power to set efficiency standards which are greater than existing standards, with the potential to reduce further carbon homes. The policy in the WMS aims to improve the consistency of application and so on. And then it goes on to say, our assessment is that any energy efficiency improvements above these standards would return marginal carbon saving benefits compared to the cost lift of up doing so. I mean, they seem to be weighing them and saying the benefits of having the flexibility to move above will actually result in marginal improvements. And that's got to be weighed in the last paragraph against the potential impact on housing affordability and availability. It does seem to be weighing all these things in the way that presumably ministers in this area will understand.
Well, our submission is that doesn't evaluate the policy against the criteria or the
So this document is inadequate, irrespective of what happened in October.
Yes.
This document is inadequate.
Yes.
So what should it have done so as to properly apply the EPPS? What more should it have done?
Well, what we say is to be taken here is both that redacted ministerial submission and the EPPS analysis together.
Yes.
And that what needed to be analysed at this juncture, jumping ahead in my submission, so I'm just reformulating where I'm at, but is that the decision was carried out with an open mind and rigour, assessing the policy against the EPPS environmental principles, and taking the submission together with the policy, we say that a fair-minded observer wouldn't regard that as an open-minded and conscientious and rigorous analysis.
The judge thought it was. You've got to show that she's wrong. Because we're not a judicial review court, we're a court of appeal.
Yes.
Where has Justice Lieven gone wrong? She took a different view. She read it and she thought, yes, this is actually open and conscientious.
And just understanding the way this document is structured, it does seem to be setting out relevant, as it sees it, relevant principles from the EPPS, starting at the bottom of page 24. These questions explore which of the 5 principles are relevant and why this isn't the case. And it then goes through the 5 principles, including integration and protection against negative effects, for example.
So our principal criticism of this is the we've been through it, the reference to the Future Homes Standard as future policies. So it doesn't apply those principles to the WMS.
So that brings us to the decision that was made, and then I think the other bit you've got to cover on the factual analysis is why October 23 was inadequate.
Yes, my lord. Yeah.
Before we get to your submissions on ground 1 and ground 2.
In terms of taking my Lord Justice Lewis's point about the error of the judge, we say that the error on that was in her understanding of what's a rearguard defence. So taking that concept from the PSED analysis, the concept of a rearguard defence is one that is directed in the shadow of litigation towards creating a rearguard shield to the litigation. So it doesn't preclude in all circumstances a retrospective analysis, but it's
got to be done conscientiously, rigorously, and with an open mind.
But the open mind has to focus on what the duty was in the December decision, and that the minister doesn't do. So the minister doesn't sit there and say, here I am I to adopt this WMS? Let me look at the way in which the policy has been developed. Let me look at the options that are put in front of me. Should I accept these options? Should I accept the variations that have been made to the policy? What she does is very much in the mode of the retrospective PSED type analysis of just conducting an assessment of the policy.
She's deciding whether that policy should be maintained. And in order to decide whether the policy needs to be maintained, she looks at the substance and she looks at the EPPS. And in paragraph 44, the judge says they did that conscientiously, or the minister did that conscientiously and with an open mind. I mean, I can't see how you can get beyond that.
Because what she's trying to cure at this juncture is the error that was omitted.
No, she's not trying to cure anything. She can't. She's not Einstein. She can't reverse the physics of the world. That error happened. She knows this happened. She should have been told, and she wasn't. Or she can decide, when she starts again in February or March, is, shall I maintain this policy? That's the question. Should this policy stay in place? She's not carrying out a judicial review exercise, marking herself or her officials out of 10 for the adequacy of their duty performance in October, November, December 2023. She's trying to decide, should these words remain the words that govern what happens now? And so long she's done that conscientiously and openly, and had due regard to the EPPS, I can't quite at the moment see what the criticism is.
On my Lord's analysis there, what that misses out is any analysis as to the development of the policy. So all she's doing, at the stage at which the policy is adopted, it's a finished object. There's no question of any options or variations or possibilities. So that then loses the EPPS analysis of the development of the policy. So that's the bit that isn't ever repaired by looking
You
at
can
it
never be
again.
prepared on your analysis unless she starts again with a completely blank piece of paper.
No, it doesn't have to be completely blank, but she could look at the options that should have been presented to her in the December analysis, and she can make her mind up in the context of the formulation of the policy. That she hasn't done, and that's all this goes to remedy. That's why we say it's important that the court does declare the flaw, not only in failing in December to comply with the duty, but in failing to make up the omission in the March analysis.
The March failure is the failure, can you put it in one sentence? The failure in March was?
To have due regard to the making of the policy in the sense of the development of that policy.
Yeah, instead of using the word, can you describe the state of affairs that you feel have due regard to? The failure in March have due regard to what exactly?
The development of the policy.
Over what period then?
Well, over the whole period of its development, but with a particular focus on the options that were available in terms of the way in which the policy is designed or formulated.
There's the options in July, is that right?
Options had been considered throughout the process, so including...
yes, but what are you referring to?
Well,
because earlier on you said you don't particularly criticise the July.
So all of those options. So if the July options had been dealt with in October, then I've already accepted that was sufficient analysis for those options. If dealt with in October, then you're only left with the further options beyond October.
Thank you.
And so we don't see either in December or March any analysis of how additional words come into the policy between October and December, any alternatives that were considered, how the policy is formulated. We just see the presentation of a complete policy without any consideration of how lesser environmental harms might have been achieved, for example. To put it in very
all this assumes that where you have a policy which is being developed at a time when the duty is not in force, if you take the decision to adopt once the duty is in force, then you've got to comply with the duty as if it always applied during the process of development, although it didn't.
Well, that problem doesn't arrive with the November-December changes because the duty was in force.
From the 1st of November?
From the 1st of November. So for those later stage changes...
We know what those changes are, but you're insisting that we have to look at options 1 and 2 going back to July, and you say this wasn't dealt with in October. And this is a criticism, a legal criticism you're asking us to endorse on the basis, nonetheless, that the duty wasn't in force at the time.
Yes.
And there are no transitional provisions that I've seen in the legislation.
Yes.
Okay. So effectively, it's having a retrospective effect.
Well, it's not that, because the bite is when she makes the decision.
Yes.
But it's what she has to have regard to in the making of that decision.
I appreciate that, but the bite, when she makes the decision, relates to whether or not you took into account how the principles were taken into account at a time when there was no obligation to do so.
The development of the policy is the duty, yes, and so that can be a development that took place before the duty came into force. Yes, that's I would submit it's implicit in the language of the statute itself.
Well, your point is that in fact the duty applied in December and the policy was adopted in December. So in December the duty had to be met. So from the 1st of November onwards, if anything happened that could remotely be called development, she's got to look at the PPS in relation to that.
Certainly from November onwards, yes.
Yeah. And the other side, as I thought, was saying, well, even if that is true, I understand them to be saying that in substance, that which the law required from the 1st of November had in fact been done in October. You disagree. And if that's the case, and you seem to agree with that, if that is the case, all she has to do is assess any changes or refinements to the policy.
Yes.
And if it's not the case, you say when she comes to look at the policy in December, she has to look at the whole shooting match, because she can't be sure that's what has gone on before will remedy any obligation that she's got to make sure that that which ultimately emerges has had due regard to the EPSS. I'm not sure that the references to developing policy of rearguard action really helps. I think the key issue is in December, had the previous parts of the policy in substance been assessed, that there was only a need to look at the changes, or had the state of affairs never been properly assessed, in which case she'd have to make sure it was properly assessed in December or indeed in March, because that's what she'd have to do.
Yes.
So simple as that, really.
Yes.
And regard action and development of policies don't help.
Well, they do assist because what we see in the actual submission to the Minister is it's all based on this litigation. We see that. Virtually everything is redacted.
That's how they discovered the error, yeah.
Yeah, but what the Minister's told or asked to do is to demonstrate compliance.
No, it's asked to revisit the policy and to demonstrate compliance.
Yes, in order.
It's asked to do two things.
In order to demonstrate compliance.
No, it's not even in order to. It's revisit the policy, comma, and to develop the policy. I haven't demonstrate compliance. I haven't got it in front of me, but it's not as you're depicting it on the words on the page.
But the rearguard action question is biting on this concept of...
Had the error not been discovered, she would not have looked at it again.
Yes.
It has happened, and she has looked at it again. And the question is the re-looking at it, A, adequate in its own terms in March 2023, and B, is it adequate if earlier considerations between July and October were not adequate? And it's actually unhelpful to add labels and so on. It's the substance of what goes on. There is a policy in place in March 2023. Did she, or 2024, whatever it was, did she look at that properly? And, or if it hadn't been looked at properly before, did she look at it sufficiently broadly enough? That's the real issue, without all the labels, with everything stripped out.
Can I make my Carlton Conway point on that, in response to that submission, which is at the skeleton, paragraph 33, subparagraph 5, just sets it up most easily.
So which page?
My skeleton argument.
The core bundle.
I hope my lord's found that skeleton.
33, Roman 5, isn't it?
Yes.
Yeah, on page 15.
And what's the relevance of that subparagraph to what we've just been discussing?
The test that the Court of Appeal applied in the Carlton Conway case is that's a case about a delegated officer's decision that's then ratified, and the test that was applied there is whether a fair-minded member of the public would be concerned that there was a motivation in the decision to avoid the consequences of the judicial review, and on the basis of that potential risk, stressing there was no improper motivation, the court found that the ratification decision was itself.
We'd have to look at the facts of Carlton Conway to see if it's the same.
Yes.
To say if the minister is lying and she's caught out, it'll be unlawful is one thing. To say that that's what happened here is quite another.
Yeah, well, I don't say she's lying.
Well, you're saying she's just doing it to avoid the judicial review, and we have to read the words on the page and ask ourselves, is that what really fairly is happening here? And just saying that in another case, that's what they found, without us knowing what was in the other case, doesn't really assist, to be perfectly honest with the... It's
in the authorities at 27. What I was trying to get was not an implication of any bad faith on the part of the minister. The approach of the Court of Appeal in that case is to avoid that necessity. Sorry, that's the wrong citation.
It's tab 8, isn't it?
Sorry, I'm breaking on. 115. is the sidelined passage at paragraph 27.
I don't seem to have it at my tab 8.
So this is general public law, is it, which reports it? Yeah.
It should be general public planning law. Yes.
Yeah.
I have two bundles. One is called main bundle, and one is called bundle of authorities. The index says 8 and you refer to 8, but when I turn to my tab 8, oh yes, I see, yes, it is the right one. Sorry, I'm with you now. I do apologise.
It's paragraph 27 to 28.
Yes, thank you.
Thank you.
Yes.
So this is an alternative submission if we have to put it that high. We say that the proper focus of the duty is, in context, is the key consideration for the court here, but in the alternative, there should be a focus on apparent lack of fair-mindedness. And if we have to reach that threshold, we say that that is what a fair-minded observer would conclude about the minister's decision taken here on the basis of that legally privileged recommendation that she takes the decision within 1 day of that, and a fair-minded observer would say, has she really had due regard, robustly, fairly and open-mindedly
So what
to
are the
the
facts?
duty?
You mentioned a couple of things. The redaction of the legal advice, the fact that it was taken within 1 day.
The content of the consideration.
And you mean the EPSS or the ministerial submission? You say content.
Well, the two are partners, so both.
Right.
So the ministerial submission we have, please revisit and demonstrate compliance, as my lord clarifies. And then the content of the submission is not, to a fair-minded observer, achieving the robust, rigorous, open-mindedness consideration that is required to discharge the duty at that stage. For the reasons I've canvassed, that it doesn't go over the development of policy and suffers from the confusion of the FHS and the WMS policies.
Can I ask a question?
Thank you.
If, having reflected on this, it's a hypothetical question, the court were to conclude that there was nothing legally wrong in terms of compliance with Section 19, with the February 2024 assessment, is there anything left of the Carlton-Conway?
Yes,
point?
so we are putting that. That's why I say it's as an alternative.
Yes, but then you see, when you are asked to say what you rely upon to support the Carlton-Conway point, you bring in the substantive complaint that this isn't a compliant section. So and that's why I asked the question, so I can see where the argument goes.
So on that premise, yes, my lord, then I'm restricted to what the fair-minded observer makes of the redacted submission and the terms of that.
But on the supposition, it's only a supposition, that the statement itself is Section 19 compliant.
On that supposition that that's a compliance statement on itself, and it only adds in that respect, yes.
Thank you.
And then we also make the point in paragraph 33b of the Skeleton argument about the duty of inquiry, and that bears on the February EPPS itself, in relation to the focus on that rather than the proper target. And we say the judge erroneously held there that the Section 19 duty could be discharged from an assessment that didn't fully assess the impacts of the policy in question against the environmental principles. but which was instead directed towards assessing the impacts of a different policy, namely the future home
Well,
standard.
sorry, is that back to the conflation of the FHS? Yes, well, I understand that. You've explained that point, but
Yeah.
this is a failure to comply with the duty of inquiry. That's
Yes.
the Tameside duty, is it?
Yes.
So that's saying, leave aside the conflation, you should have got some more information.
And it was relatively unreasonable not to do so.
Yeah, it had to be irrational.
Yes.
Cartoon.
Yeah. The inquiry needs the disaggregation of those two policies was the component of the inquiry that was demanded.
The separate, is that another way of putting that, the separate treatment, if I've understood correctly, of WMS 2023
Yeah.
plus FHS, is that it?
And yes. And that's a separate challenge to the way in which the judge determined, to the error of the judge, we say.
But as an inquiry, that's something which, if the point has force, could be dealt with within the department. It's not inquiry in some wider sense.
It's the duty on the minister to inquire. Yes.
Yes,
doesn't
this
need to
duty of the
involve going
minister
outside.
to say, I need more information from my officials. Is that the way the argument works in practice?
Yes, she needed more information upon which to base her decision rather than something else.
Are you going to take us to the judgment of the judge to show us why she was wrong? Because at 43 to 51, she dealt with all of these. I know you disagree with them, but on an appeal, you do need to demonstrate that she's wrong.
Yeah. So we've got. I'm trying to deal with that at the moment. Paragraph 33 of the skeleton article.
Oh, right.
Errors in the judge's approach. I know I need to go back to the October decision, my lord.
Whenever
I'm following the flow rather than necessarily dealing with that logically. The errors in the judge's approach are set out at paragraph 33. We say the primary error of approach is, of course, on the interpretation of section 19 itself. And we say, properly interpreted, the section 19 duty couldn't have been regarded as discharged.
But
And
this
we
is why
identified
it's
three.
not a rearguard duty. She doesn't use the word rearguard duty. She talks about retrospective, and you've accepted that it's retrospective in principle. It would be more helpful if you could show us the line, or it would help me more, if you could show us the lines in the judgment where she's simply gone wrong. Not say, this is the test and I don't think she applied it. Because what you say, she appears to have done at 43 onwards.
I'll come back to that, my lord.
Okay.
And then, so at 1 we say the section 19 doesn't permit a rearguard action. Take my lord's observation. At 2, that properly applying the section 19 duty, the judge erred in finding that the checkbox assessment in the shadow of the litigation was not merely retrospective, but not finding it was impermissibly rearguard. That was the proper understanding of the duty in context. At 3, we say she failed to appreciate the significance of the expansive definition of making policy, which includes developing, adopting, or revising policy. The judge focused on revising, and we say wrongly, because this isn't a situation of revising, and failed to focus on developing in particular and adopting, which are the components included within the term making. So there's a failure to properly apply the duty as properly understood.
In 4, you say the judge failed at any point in the judgment to consider whether the assessment was considered with an open mind. I'm looking at 2 paragraphs where she uses precisely that phrase.
She uses that phrase. What we say is that she didn't ask herself whether the demonstrating compliance aspect is I've made my submission on that, properly to be regarded as discharging the duty with an open mind. And at 5, she failed to address the appellant's alternative point that even if the court is persuaded the decision to maintain the WMS was carried out with an open mind, it's obvious there's a real risk for the fair-minded observer. That's the first class of legal error. At B, we say there's an incorrect approach to the target of the duty. That's the future homes point, which I've been through. We say the judge erred in that respect in her assessment that the articulation of the duty by reference to the future home standard was a lawful way of analysing the WMS.
What do you mean by inchoate policy?
Well, in the sense that it's still subject even now to
Has it been finally adopted?
Yes,
It's an evolving policy.
Well, it's not even in place. It's a draft policy that's subject to
But
development.
the WMS says if you, the local authority, you can go up to the level of the draft FHS. That's not unlawful, is it?
It's not unlawful in the WMS. It's unlawful for the EPPS to assess the impacts of the WMS by reference to the benefits of a policy that's not in place.
Well, why, if the WMS says you can do it? We're not restraining you to the building regs. You can go up to this draft policy, even though it's not yet been adopted.
Oh, because that's not what the EPPS is analysing. What it's analysing is the presumption that the FHS standards are in place generically as a minimum across the sector, so that those minimum building regulation standards are in place. It's not assessing the potential for the WMS to go up to the forthcoming new minimum. It's assessing the benefits of that minimum when it's in place.
Well,
so that's why it's
I'm sorry, I'm finding this very confusing. Clearly, where the WMS is restrictive, so far as local authority action is concerned, is in discouraging standards higher than the draft FHS.
Yes.
So, in terms of what the WMS tolerates, it is local plan policies which go up to the draft FHS. Yes. So, if you analyse it that way, what's the flaw? What
the WMS, what the EPPS analysis is doing, is analysing the effect of the FHS policy when it comes into force.
Well, yes, you keep saying that, but the policy says in the interim you can go up to the draft FHS, even though it's not yet adopted. I mean, when it's finally adopted, maybe it'll be lower, but so far as this interim policy is concerned, it's saying you can go up to.
Yes.
So logically,
that's not what the analysis is solely focused on. The analysis is focused on the assumption that the FHS will apply across all building once it's adopted.
Well, it only applies to housing. It doesn't apply to all buildings. There's a separate standard for other buildings,
but that's the increase in carbon saving.
So
carbon
is your complaint that it's assuming that the FHS will apply indefinitely in the future beyond the interim period of the policy?
The assumption underneath the analysis in the EPPS is that we have a new building regulations minimum standard in place, and that's very beneficial in terms of energy efficiency. That's what's being analysed in the EPPS. That's the error. Because what should be analysed is the effect of the WMS, which is limited to saying no longer go beyond this future standard, come down to the future standard. So the only thing the WMS is doing, leaving aside for a moment this idea that by unifying you get some sort of benefits by coordination, but leaving that aside, the WMS is bringing down the levels of energy efficiency that local authorities can stipulate in their plans. To the anticipated minimum standard that will be in place when the FHS comes in.
Yeah.
When the minimum standard comes in, there will then be across the board an increase in energy efficiency as against the current standard. the 2021 current standard.
Because the FHS will apply universally,
Yes. What the
as opposed
analysis
to it
does
being
is-
applied selectively by local authorities who choose to adopt it now.
Yes. What the analysis does is to look at the benefits of the universal application of the FHS rather than the disbenefits of the
Well, since
WMS.
I see. Where do we actually see that?
That's throughout the analysis that we were looking at.
Well, do we actually find a passage which says that?
Yes.
Because I hadn't detected
So if we
from
go-
the written arguments that this was the.
So it's tab 3.
Of the
Of the
Supplementary bundle.
supplementary
Page
bundle.
27 and, well, it starts at
22 through to
22.
So, starting, for example, my lord, on 24, halfway down. Will the proposed policy cause environmental effects that occur once, repeatedly, or cumulatively? Effects will occur cumulatively as more buildings are constructed to new efficiency standards over time, thus gradually reducing emissions. This effect is multiplied as the grid decarbonises. That's concerned with assessing the future inchoate impacts of the FHS policy when it's in place. It's not looking at the effects of the WMS policy when it comes in. And then on 25, under the first checkbox, the future home standard complemented by the WMS is intended to significantly reduce the carbon emissions generated by new buildings. So that's the answer to whether the policy embeds environmental protection in the policy, the integration. So the answer is, so we're supposed to be analysing the written ministerial statement, which restricts the ability to go beyond current and future FHS building regulation standards in terms of energy efficiency. The answer is the future home standard is intended to reduce carbon emissions generated by new buildings, but that doesn't analyse the effect of the WMS, which is to restrict the ability to increase carbon emissions because you can't build to net zero standards.
Beyond the
FHS, yeah.
Yeah.
So it's taking the advantage. Yes, the FHS raises the minimum, but it's analysing that effect, which is beneficial. It's not analysing the effect of the WMS itself, which is to lower the ceiling.
and I think your point on that is that the WMS was only intended to be interim, so it's banking a future benefit, which
Yes,
is never going to be there for
Yes.
the period of the WMS. Is that right?
Yes.
Well, it assumes that local authorities throughout the country don't amend their local plans so as to take advantage of the FHS in the interim.
Well, in the 2 year period that applies,
But that's your
there's
submission.
no universal application of the FHS. So all that the WMS is doing is for those local authorities who want to go beyond the existing minimum in L, they can now only go up to FHS. So it's limiting the ability to go how far beyond the minimum you can now go. And we see it again on 26. The question is the rectification at source question on the bottom of 25, and then it says prevention of environmental harm is possible through the policies we are proposing. The reduction of carbon emissions will have a positive net zero effect. So it's talking about the reduction of carbon emissions. That's attributable to the raising of the minimum for the FHS when it comes in due course. It's not about the restriction on the effect of carbon emissions that's been put in place through the WMS policy.
Is that you finished that bit of
Thank you.
the...
I'll stop there.
Yeah. Okay. Well, that's great. Well, thank you very much indeed.
You won't forget the criticism of the October document as well.
We're going to start with that when I get back.
Thank you very much indeed. We'll look forward to seeing you all at 2 p.m.